Hello, mic check. Hello, mic check. 1, 2, 3, 4.
inconvenience caused due to the delay. Before we start, I would like to request Sheridan to please come and felicitate Mr. David Whincup. Now I will try to request Tamu Mehta to please come and felicitate Ms. Sheridan. I'd like to request Advocate Mediator to please come and felicitate Sri Chetan Bhagwat sir. Again, I thank each and all of you for coming here and gracing this occasion. To start off with, I request R. Santhan Krishnan to welcome everyone to this interactive mediation session jointly organized by Commonwealth Lawyers Association, Mediation Initiative, and Nivaaran Supreme Court Mediators. Santhan sir is the Honorary Life President of the Commonwealth Lawyers Association. Sir, please.
Good evening, everybody. Dignitaries on the dais. Greetings to one and all who are online from across India and across the Commonwealth. Respective greetings go to good morning, good afternoon, and good evening. On 1st of July 2024, I attended a UK mediation conference where I happened to meet Caroline and David. It was a one-day conference, exciting, absorbing. I was fully there, and in that, during the course of the conference, I interacted with Caroline and David, and that interaction did not stop, and she is here. Thank you so much for accepting it. Over. I welcome you all on behalf of the Commonwealth Lawyers Association, Mediation Initiative, and Nivaaran, the advocates of Supreme Court.
Thank you, sir. May I now request Senior Advocate Rajiv Patil to please introduce the session for all of us. Thank you.
Good evening, ladies and gentlemen. We are a bit late. I know, but in Mumbai, we run around the courts and we get busy in that court proceedings, and somehow we find it difficult to adjust our time. So I'm sorry, some inconvenience caused. Now today we have a well-known mediator from UK, London, who is the CEO, Sheridan, who is the CEO of Sheridan Worldwide. Now, Caroline is the founder of the mediation process as such, I would say, and she is highly regarded as executive coach and mediator, whose focus is very much on the helping people raise self-awareness, realize their full potential and strengthen the professional relationship. Caroline's warm and engaging approach is outcome-focused, aligning individual, team and business aspirations. She works to achieve specific objectives and particularly adept at helping to build an effective communication toolkit to both influence and empower. Now, so far as her mediation abilities are concerned, that Caroline has built successful practice as the leading mediator in the years since qualifying with CEDR in 2006. She has consistently appeared in both the chambers of UK and Legal 500 directories. Caroline is regularly sought to mediate the workplace employment and commercial cases. She specializes in the repair and restoration of valuable relationships which appear damaged beyond the limit, and her clients cite her as their go-to mediator when seeking to strengthen the professional work. I would like to just inform that the process of mediation in India is limited to certain areas, mainly the family disputes, the disputes relating to business disputes, business issues. We have a system called pre-institution mediation, that before you go to court of law, in your commercial dispute, you are mandatorily required to approach the mediation process, and everything depends after the result of the mediation. Now we have another guest, Mr. David. Mr. David Whincup is the legal practitioner for more than 40 years. He is specialist in employment law and covers wide variety of employment related issues, including individual and term recruitment issues, policies and contract drafting, disciplinary and grievance procedure, individual and collective redundancies, and the other litigation. Now, so far as the employment law, when we deal with in India, we have several aspects because of enactment of new laws in respect of workman's harassment or the employee's problem for the employer. So we look at this particular issue in a very different perspective, because if at all I have to enforce the rights of the employee, then in that case I may face too many difficulties in mediating the issues between the employer and the employee. And we would be very happy if you can guide us in these areas of employment law, so we can apply our best skills to mediate the employment law or the workplace. Thank you very much.
Thank you so much, sir. We'll commence with some questions. Instead of this being a presentation format, we thought it would be more of an interactive session to have a question and answer format. Now, the topic of today's session is workplace mediation. And as soon as somebody hears workplace mediation, at least in India and the people that I have interacted with, it seems like a very foreign concept. And the immediate reaction is, what would a mediator do in the workplace? It's the job of the human resources department, and a mediator or maybe a lawyer has no role to play whatsoever, right? And why would a mediator make any difference? Why would anybody choose a mediator? The HR department is enough. But then on the flip side, people, especially the employees, say that the HR department is on the side of the employers. So they can never be good mediators and problem resolvers. So we have these notions in mind, and even I'm not clear about what exactly goes on in a workplace mediation. So based on the kind of questions that I had in mind and in discussion with my senior mediators, we formulated some questions. And with the first question I have, And Caroline and David, if I may address you as that, I'm going to ask the question to both of you at the same time, and amongst you, I leave it to you to decide who feels they can answer the best. Now, the first question I have is, how do you see mediation evolving as a standard practice for resolving workplace disputes in the next decade? And which types of disputes are generally seen in the workplace and are amenable to mediation?
Thank you for here, and thank you. It's lovely to be here. It just takes me back what you just said here about my own journey in 2006 when I trained as a mediator, and the fact that in the UK I was talking all the time to HR, having been an HR practitioner myself, and no one knowing or understanding at all in the UK what mediation was and what mediation wasn't. And that was my journey, talking to people to get them to understand it. And we're still doing that very much so. We're still educating. Education, I think is so important. So this is a journey that we're all on. I'm just reassuring there. So really over the next decade, we anticipate that mediation will become more integrated into workplace culture. Certainly that's the hope in the UK. We do see signs of that. We do see that happening in other jurisdictions in the US, for example in Australia. And in the UK, the UK government's own framework, ACAS, Advisory Conciliation Arbitration Service, mentions mediation only in its forward to the ACAS code, and we do see, particularly with change to the UK government more recently, a drive to embed that in its main code. And what that means is, with or without that, because we already have the ability from the bill, we see companies such as the BBC and Civil Service and others embed mediation in what we call a resolution framework to really kind of make it more informal options for people to think about first stage, because the cost of conflict in the UK alone annually is £28.4 billion pounds, according to ACAS, which is a huge cost to industry. And if we can see that dropping drastically with a massive investment over the next few years in conflict skills for managers, conflict skills for everyone. So even at the point of recruitment, when someone's joining a company, I mean, I would want to join only a company that would say to me, when you have conflict, Caroline, we're going to help you resolve it. And you know, we're not going to go through the traditional age-old adversarial processes that are currently in place, because there's another way, and mediation is a way forward. It may even be renamed over the next decade. For some people it can sound a little formal. And we have also seen, and I personally have been operating as a joint coach at times to preempt conflict, particularly in co-head type roles, where we really want to help people align on ways of working. David.
Thank you. That's part of the answer to how mediation will evolve. The other half is why, and there is a very simple answer to that, which is that it's much better than the alternative. The alternative of formal legal proceedings is slow, expensive, you are in somebody else's hands. You may ultimately get a legal resolution of your workplace dispute, but you won't have a real one. Those people will still be at odds with each other. It's just that one will be very smug and the other will be very bitter, and that's not a good way forward. The other reason I think it will go is because this isn't a big request of people. Mediation, you know, is conceptually very simple. It's about putting two adults in a room together and asking them to have a grown-up conversation about things to their mutual advantage. Nobody is doing anything very complicated. It is about using human nature, and unless and until we get court systems around the world which are faster, slicker, more reliable, less expensive, then mediation over the next decade can only grow.
I think you asked about what types of disputes. They're very much interpersonal conflicts arising from personality clashes, communication breakdowns, misunderstandings between people, performance issues in the workplace, people struggling to give feedback, afraid to give feedback, not giving it, and so forth. And lots around bullying, harassment, victimisation, and often, you know, when we come to mediate those very claims, such as, for example, bullying itself often that's a label for poor management, and disputes perhaps over workplace policies as well. So there's a lot that come up, and in fact many things can be mediated. And David, you might have a view on that.
I have a view on most things, yes. It is actually easier to ask the question, what can't be mediated? And the answer to that is very little indeed. Wherever you've got two people who can see a solution, you've got something to aim at. Outright misconduct can't be mediated. It's misconduct, the company needs to deal with it. Overt poor performance, the same. Fear of physical violence, potentially, where one party is clearly not taking it seriously, potentially. I've written a number of articles which say, well, why don't you mediate sexual harassment allegations? And there is a lot of sucking of teeth and not really sure that you can do that, but actually forcing those through a formal process overlooks two very important considerations. The first is that under English law it is possible to harass by accident, completely inadvertently. And the second is, what happened to the wishes of the victim? Maybe he or she does not want a formal process with all that means. So I think you can mediate pretty much anything except where the employer needs to make a point. This is not a negotiation, this is about compliance. Pretty much anything else, it's worth a go.
Thank you so much to the both of you. I'm sure that with a room mostly full of lawyers, there will be a lot of contentious arguments based on what can or cannot be mediated. But what I'm going to request all of you is, if you do have any questions or comments, we can definitely take them at the end of our question round. And even those who are on YouTube, you can definitely type in your comments or questions, and we'll definitely try to take them up at the end of this session. Now, going on to the next question, what I would like to ask is, as I said in my introduction, most people feel that HR departments, they have the domain in dispute resolution, in employee management, in behavioral conduct. So, what edge does a mediator have over the human resource departments, and how does that help you in integrating mediation into the workplace culture?
What edge does a mediator have over the HR department? Sometimes a mediator can also be HR, sometimes. It depends really on the structure and size of organisations. We find some companies, look to have a few internal mediators as well, providing they're in CPD and in supervision. That would be very important, and a large enough structure that they could mediate impartially. That would be very important as well. Do you find often also these days that where there is internal mediation, it may sit outside HR in order to be seen to be very impartial, maybe in wellbeing even section, maybe the East Lancashire Healthcare Trust placed it in a different division to HR as well. But as a mediator, the edge you get is the fact that you are impartial and that you work in order to help parties own their solutions to an issue. And when things sit at HR's door, if it ends up going down the formal grievance route, typically parties lose control and they have little influence, in fact no influence really, on what happens at the end of a difficult and lengthy grievance process where there are no winners. And perhaps someone will go off sick, or perhaps productivity will drop, maybe people will leave, maybe we'll lose some really key people that we really enjoy working with at some level within the teams, and that's a tragedy. And that's really what brought me into mediation many years ago, was a desire to see high-performing workplaces where we could really tap into people's brilliance, and often it just takes understanding people.
So I'd add a slight refinement to that. The key, yes, is impartiality, but it's actually more than that. It's not just actual impartiality, it's perceived impartiality. So you as an individual person in HR may genuinely be impartial, but if you have perhaps a history of supporting management, or if you're very friendly with that employee and not that one, then it doesn't matter. internally what you think, how good you are. So quite common in the UK for large organisations is that HR in one office may be the mediator in a different site. But I think it's quite difficult to be impartial, to behave completely equally when you may very well like one of them more than the other one, you may well believe one of them more than the other one. It's a tough thing to do, and I think that's where the external mediator has the edge, because not only are they not invested emotionally in this in any way, but they are clearly not invested, and it's all about the perception.
Great. Now, most of us are aware that generally the benefits of mediation over litigation are cost effectiveness, less time consumed in resolution of the dispute, a win-win situation. Now, going beyond these generally known benefits or advantages of mediation over litigation, do you find that there are any other aspects of mediation with respect to UK labour litigation in particular, which are peculiar and make a case for choosing mediation over litigation?
Definitely. There's a handful of them. They're mostly functions of the law, but in most employment tribunal cases, our equivalent of the Labour Court, your costs are your costs, whether you win or lose. So if you combine that with the fact that compensation for a lot of legal wrongs is actually very limited, you get to a situation where you can fight your case all the way through, you can win, and your legal bill is bigger than the amount of money that you won. So even your best case is not great. Your best case is losing, or your best case is winning an amount which is simply not worth the stress, the grief, the uncertainty, and so on. So that is important. In more broad terms, the employment tribunal system in the UK is grossly underfunded, so it can be easily a year from a claim to a hearing. And of course, if you're still employed, then that year is a nightmare for absolutely everybody with live litigation between you. And the real problem is that employment litigation doesn't fix anything. The relationship which was damaged at the beginning is as dead as a nail by the end of it. Maybe you won, maybe you lost, but the relationship is dead. And litigation involves lawyers, lawyers take strong positions, lawyers send strong letters, and the whole thing becomes like an artillery duel at your expense, at the employee's expense. It's simply pointless. So mediation, I think, has a huge advantage in employment law over most other disputes where maybe it's not your money, it's not your life.
On any repair. Can you give us any instance, maybe you, Caroline, or you, David, of how a dispute that turned into a larger conflict and then it was ultimately resolved through mediation?
So yes, I can think of a recent dispute between a manager and a union official. That was initially at a very personal level, but what happened was that developed into a much bigger dispute between the union and management much more generally. And that led to some very, very unattractive behaviours, with posters going up in that company's building about the other side, which was detrimental to how management perceived by the rest of the staff. So that led to a very divisive relationship between management and unions. That led to mediation sessions between both sides. There's about 23 people in total it's quite expensive as well at the end of it for the organisation in question. And it was really around learning to disagree well, because they didn't know how to do that. And that's really what led down to the breakdown between management and the union as well. More than one union, in fact. We're not talking about just one union. In the end, it spread to infected other unions as well. And then we had to basically work with all sides to create a partnership agreement and to put in place a process that they where they could respect, recognise, respect and respond in future, so that there were ways to avoid any such repeat.
Thank you. Now, Caroline, as one of the few women in the CEDR chambers, do you encounter any unique challenges, and do you see any opportunities for women mediators in workplace mediation?
Okay, there's always a risk that in answering a question like this you kind of reinforce stereotypes. So male and female mediators have skills in terms of empathy, commerciality, robustness, pragmatism. Not a skill that innately favours either male-female mediators. There will be disputes sometimes that David and I have found this where it might be that a particular party prefers to work with a female rather than a male. The same can be said of the opposite sex. I had one recently for a company, a law firm, contacted one of my team this week asking initially for a male mediator, and then on the phone immediately checked herself for bias, and so, because she was thinking she needed a strong mediator. And females can be equally strong, right? So that was interesting in itself. But the thing here is, what do the parties need? So what's going to set this up for success? And there may be other things, not just whether a male or female, that might be need to take into account. It might be background experience, it might be knowledge of a particular industry, there might be many things. So I think that, really, there could be an instance, I suppose, sometimes where someone might be more threatened by the presence of a man, depending on the case. And that would be something definitely want to take into account as well. So of course, in terms of challenges and opportunities, there will be men, I suppose, in a mediation that might not want to be told what to do by a woman, but the whole point about mediation is we're not telling anyone what to do, we're asking great questions and creating an environment where people can really think through what solution is relevant for them in order that they own them. And as I said earlier, that's something quite different from other formal processes. Because mediation is so much more easier to get into than being a judge or a lawyer. David, you might have more to say about this. Nothing? So just joking. Is that helpful?
Yes, definitely. Thank you so much, Caroline. And now my next question is for David. You have extensive experience in employment law. I said 40 years?
Yes.
Yeah, that's a lot. So with this 4 decades of experience, does the knowledge of the legal framework enhance a mediator's ability to address a particular dispute?
I think the answer to that is yes, but nowhere near as much as you would think. You're not acting as judge, you can't advise, you can't correct, you're not interested in who is right and wrong under the law. So you might think, well, knowing the law doesn't really matter. You can't appear biased or not biased, but predetermined. So why do you need the law? Well, I think it helps because it helps you ask your questions. So you can't say to somebody, but that just isn't how it works. But you could say, how sure are you about that? Or maybe that's a point you could talk to your lawyer about and indirectly force the lawyer to give the advice which they maybe need. You can't also escape the fact that the expectations of the people you are with are governed by what they think the law says. And so if you know very roughly what they've probably been told, then you've got a better sense for what's going to fly and what's not going to fly. I would find it very difficult mediating in a discipline I knew nothing about. But the opposite of that, Caroline is not an employment lawyer, but mediates very successfully in the workplace. So on balance, yes, but is it a legal necessity or a big difference? Probably not.
Okay. That probably answers this question that many people have. Now, one of the reasons we thought it would be beneficial for us to have this conversation with you is because of your experience in different jurisdictions. So, thinking of different jurisdictions, could you talk about the different approaches to workplace mediation around the world? Do they differ at all? Are they the same? And if they differ, are there any particular practices that you can identify from different jurisdictions that could be adopted globally to enhance mediation practices?
So just a small question there. Okay. I don't think that there is, at its heart, very much room for global differences in terms of mediation, because it is ultimately that grown-up conversation between two people with some commonality of interest. So the difference is not the process, it's not the mindset. It may be a difference as to when in the dispute process it's used, but certainly, in Australia it is immediately pre-court claim, but maybe if it had been done in the workplace, it would have been avoided in the first place. In the UK, again, ideally done in the workplace, there is a sort of diluted version of the Australian requirement for prior, well, it's conciliation, which is a much less powerful weapon. But in the end, mediation is mediation. It's about human beings, not law, not facts, not cultures, not religions, not politics. It's about what two individuals can live with. And there is a basic saying about settlements generally, that the mark of a good settlement is that it makes both sides equally unhappy. And that's what mediation uses, and that is true worldwide. So maybe some of the terminology is different, maybe the exact moment of introducing it is different, but human nature is human nature, and so I think it would be recognised anyway.
Wonderful. Thank you. Caroline, any inputs on that? All right, thank you. Going ahead, going back to an earlier question where we talked about the introduction of mediation processes in organizations and the perspective that human resource departments are generally pro-employer and may not be able to remain impartial. So how do mediators balance this power dynamic between employer-employee disputes to ensure the impartiality and fairness?
Well, I think it's about how if we think of the word fairness, I think it's about fairness of opportunity. Mediator's job is to look at fairness of opportunity, not fairness of outcome. I think that's probably a key difference. And that's done by setting out the ground rules in what we all know to be the mediation agreement early on, so that one person's voice is as valid as the other person's voice, and that one side can have all the most expensive lawyers in the room, but it's not about law, and so the extra value they may bring is very limited. So equal voice, addressing any imbalances, and creating a very safe space for people to really speak up and be heard. And each side has the same opportunity to end mediation, to walk out early, but then when we contract for that as part of the ground rules, I'd always say, and that's precisely the moment in time I would ask you to stay. And each side has the same opportunity to talk about confidentially whatever it is that's holding them back from being able to kind of think more clearly about what can they do, what can they do differently, as much as the other side to kind of move things forward. We can separate the parties from the lawyers, and Dave and I were talking about that yesterday, weren't we? We often do that. And also bringing the parties together without the lawyers can also help power dynamics as well, if there's any imbalances in the room as well. So in the end, both sides are there to get a settlement, and the mediator's job is to really manage a robust process in order that the relationship and the process and the content are given, fair, equal value for people to really experience an impartial mediation.
Could I add one thing to that? There's something else that mediation gives you, which is the opportunity to speak direct, face-to-face, eye-to-eye with the person on the other side, which is an opportunity as a junior employee you may never have had before. But that person, that manager, is bound to let you talk. A couple of minutes, not more than that, to give you the opportunity to be heard. No interruptions, no denials, no arguments. Just hear me as an individual, and that is a great leveler. That it's very, very equalising of we're both just human beings, and I have as much right to say stuff to you as you do to me. And that is, even though it happens right at the beginning of the mediation, the impact which that has is often what unlocks it later on. So I think in terms of power dynamics, I personally think that's the most important bit. I get to say something to you which you may not like, but you can't do anything about it. Great.
I'm going to combine the next two questions concerning mandatory mediation. I believe there were some steps taken recently in the United Kingdom regarding mandatory mediation. So, can I ask the both of you to give your opinion on this concept of mandatory mediation, whether it should exist, whether it does give any results, whether mandatory mediation means a mandatory resolution as well?
Well, let's answer that in the other order. Mandatory mediation cannot mean mandatory resolution because you can't force people to agree to something. So get rid of that one. I don't think that you can have mandatory mediation. You can have a process, but there are examples, there are cases where it's simply not appropriate. And not many, as I said earlier. So 100% involuntary mediation takes away a key part of what makes mediation work, which is that it is voluntary, maybe reluctant, maybe hesitant, maybe scary, but ultimately voluntary. And if you say you have to do this, then I've lost control, and the bit I thought that I could control is gone. So mandatory, no, I don't think it works. I don't think it's sustainable. I think it's potentially actively damaging to the process in terms of getting employee buy-in. But there's a very big difference between mandatory and strong pressure. Strong pressure from employers, strong pressure from lawyers, from courts. That's a different thing. I'd be all in favour of a lot of encouragement and pressure, but I wouldn't be in favour of 100% mandatory because it just destroys the process.
And just to add to that, I think the movement we're seeing up to the UK is about early resolutions, about making mediation or looking at other informal ways of using the mediation toolkit, looking at facilitated dialogue, facilitation, conflict coaching, other aspects to kind of really embed it as a first step before more formal processes take place, and also training managers in these skills and all important skills as well. So there are other ways of really embedding mediation in the workplace so people start to really understand it and work with it. So actually when faced in conflict with something new like mediation, particularly people haven't heard of it before, they're quite scared, and they're already scared. So if you try to tell someone about something new when they're terrified, it's very difficult to engage.
Excuse me, when there is no free consent...
Sir, we will take questions at the end of the session. Thank you.
Certainly.
Moving on to the next question. mediation clauses, employment contracts. Would you recommend a tiered structure for dispute resolution even in employment contracts? Generally, we see this tiered structure in commercial contracts where there is negotiation, mediation, and then arbitration. Would you recommend something like that in employment contracts as well?
No. Anything else? Right. No, because it's the same point. It's the mandatory point again. Saying you will mediate any dispute isn't going to work. Saying if you have a dispute, we may recommend mediation, and without very good reason we will expect you to do that, does work, because Indian law, I'm sure, is the same as UK law, is that there is an implied term of every contract that an employee will comply with a reasonable management request. And if you think of the statistical success rate of mediation, the speed, the economy, the flexibility, the discretion, then it's only going to be in very rare cases that won't be a reasonable management request. So I think, yes, manage expectations very strongly. Yes, make sure the clause contains or refers to the information that the employee would need to understand to know what they were doing, but not an outright contractual obligation for the same reason as the mandatory problem.
Anything from you, Caroline, on that?
Nothing to add, thank you.
Okay. Coming on to the next question now. So, thinking of workplaces, they are very dynamic, they are diverse. Now, India is a very highly culturally sensitive country. Even in this audience right here, we have probably 10 cultures represented, at least 10 Indian cultures represented, at least. Now, we are sensitive, we are more or less aware of Indian cultures. But many of us are not aware because of the lack of exposure to international cultures. India is also very hierarchical. Positions and age are respected and sometimes even feared. How can mediators navigate such cultural sensitivities and hierarchical structures that are so deeply ingrained, even in workplaces?
I think the first word that comes to mind is respectfully. Very much respectfully. These questions you have are very similar for us also in the UK. The UK now is a very diverse culture, more than it used to be, very much more so. And also there are equally some hierarchical structures in some organisations where hierarchy is everything. Even where some people who are very senior who are trying to break that down, it's very difficult to break down because other people around them are so used to it. So I think very much for a mediator, it's being aware of those cultural norms of the population which you're working, and to check in with people as well. That might be part of the brief of the organisation who's engaging you, first stage, do we understand what's happening with the people, what's the hierarchy, what's the impact, anything to perhaps be shared confidentially, as much as then with the parties when you meet the parties for the very first time, and to check in with them and ask what specifically do you require of me as a mediator, how can I adapt mediation in order to be sensitive to your particular needs. I think here too, also it's around the mediation agreement and it's around understanding equality within mediation. It's different from hierarchy outside it, and if need be, discussing that with parties as well so that we're really clear that hierarchy leaves its place outside the door in order for us to truly come as two equals here in mediation to really resolve something that really matters to both people. And I think it's an important question, and maybe it's something we can explore further, because it would be a shame for a mediator not to set the mediation up for its best success if these things are not properly addressed. I think, David.
I'm going to take a slightly different view on that. Yes, respectfully, but only up to a point, because in the end, if the mediator is seen to be too respectful of one party's culture or views, then that begins to look like impartiality. So to my mind, your position in society, your culture, your age, is no different from any of the other personal things that may be going in your head to decide whether a particular agreement is acceptable to you or not. It might be money, it might be family, it might be religion, it might be politics, it might be where you came from, it might be... They're all just ingredients which go into that big noise in here, and not everybody is equally adherent to their own culture or equally respectful or disrespectful age-wise. So I think in terms of logistics of a mediation, yes, you need to be aware that somebody may require a break for cultural, religious, whatever it is, reasons. But once you're in there, I think there's less need maybe to be, not disrespectful, is not the point at all, but in there, you're two human beings, and that's how it should stay.
I think just the thing just to add there is in any mediation, the mediator would be very sensitive to requirements, so eating or praying or something else needs to have at different times, or I even, I've worked similar recently and had stuff at 4 or 5 a.m. in the mornings and needed to have a break by 11 to have some early lunch. There's always ways of kind of looking at what we need to do to create that environment. Thank you.
There's lots of food for thought there. Now, I apologize considering the unfortunate delay that we had. I'm going to skip a few questions and I'm going to move on to the last 3 questions that we have. Now, as practitioners, mediation is definitely an effective and a very powerful process, but it is not sufficiently embraced by, whether it's what I see courts in India, whether it is companies, whether it is other kinds of organizations, NGOs. There could be various reasons why people don't want to mediate and why they feel like it could be possibly a waste of time, because they have already tried it with somebody they know. They said, we often get this, oh, we have an uncle who tried to mediate. Or we have this person who know he is well respected in the business community, he helped us out, but that mediation failed. So how do you deal with such common objections to taking part in a mediation? And how do you address then the issues of confidentiality? And then do you wish to see any formal action being taken for any breaches?
So, addressing objections involves educating the parties about confidentiality and the benefits of mediation. And we talked a little bit about that earlier, addressing their concerns and so on. Anxiousness about confidentiality is a key one. Of course, we talk about this in the mediation agreement. What's said in the mediation agreement, what's said in the mediation is confidential. So, if you and I are mediating, what would be said would be confidential? I wouldn't be sharing anything that you share with me with the other side. Equally, the same confidentiality process surrounds both parties and the mediator as well. But reassuring people of that happens not just at pre-mediation and in the agreement that's written down, but by the mediator throughout to kind of instill that confidence in people that was said and restating those ground rules. If someone breaks confidentiality agreement, you might want to speak about that, David.
Yes, if the mediation succeeds, you have an agreement. Whether it is confidential depends on what the agreement was about. If mediation fails, nothing that happened in there can be disclosed. Now that's easy for me to say as mediator, but sometimes employees say it, and you'll never guess, and he said this and I said that, and it all begins to go terribly wrong. But the promise that it's confidential is a contractual promise, which means that if you improperly leak information from a mediator, from a mediation, then that is misconduct, pure and simple, and can be treated as such, just as if you had leaked any other confidential information about that employee, their salary, their illness, their health, whatever it is. So there are teeth behind this, quite big teeth. And the answer to some of these questions about, well, why should I? There's a simple legal answer, which is because the alternative is much worse. It's much less confidential, it's much less quick. It's just worse. So you can't make somebody go into mediation laughing and skipping because it's a scary and sometimes difficult process. It's not an easy way out. It's a hard day, but pragmatically it's just much better than the alternative. There's no way around it.
I think when my uncle mediated, we find that also in the UK where people may use the word mediate when they're not mediating and they're not trained mediators. That's sad, because that just damages the reputation of those that are mediators, because the process is so robust and creates an incredible and safe environment for people to speak in a way they've never really spoken before to anyone, and that's very freeing. That's hugely freeing to surface your impact and for someone to truly listen to you. And sometimes that just helps shift people to reframe sufficiently to be able to see that actually there is hope where they thought there was none. I find that when I go to mediation, people feel it's totally helpless. Their situation is helpless. Maybe the organisation's out to get me, to let me go. Far from the truth. And they have so much more control than they realise. And I often say, actually, this is a real investment in you. It's an investment in your colleagues as well. And that everything is actually possible. And that is so true. If we look around at all of our life, everything is actually possible. You just have to believe it. You have to. And so as a mediator, it's a bringing hope as well. It's a really important thing to leave you today, that we bring hope to a world that's riddled with conflict. And as mediators, we all have a place in that world to make a difference.
Hope, that is what we all have now.
I can't really top that as an ending, except to say that I think I met that uncle, and he was really difficult. So it is true at a detail level. How many workplace disputes are genuinely completely one-sided? Very, very rarely. There's always a bit of blame everywhere, and so the best thing we can do, you can do, is sell this process. And the best way you can sell it is show that it works. And the best way you can show that it works is do it. Once you see it in action, particularly if it's you would not believe the amount of feedback for mediators which begins, I didn't think it was possible, but. And if you can get just a couple of those examples in your workforce, in your client's workforce, then those people will become advocates with you. So if in doubt, do it.
Excellent. Second last question. Do you think mediation in the workplace can improve individual as well as corporate performance? Does it affect the bottom line and top line?
Absolutely. I mean, my wider business is all around, realising brilliance in people and organisations. And I run the business and I mediate. And I do that because without mediation, it's just not possible for organisations to realise their brilliance, actually, because there isn't enough conversations day to day between people, managers, employees. Managers are terrified because there's so many grievances and they're not sure how to give feedback anymore because people want it but don't want it when it's given. And it's becoming very difficult. It is, as I said earlier, the cost of conflict is 28.4 billion according to ACAS in the UK alone globally, annually in the UK. That's a huge figure. Cost to industry is absolutely astronomical. So the way to make workplaces more productive and to increase the bottom line is to deal with and eradicate the cost of conflict by putting in place processes where people can really thrive, 100%.
Yeah. If I think as an individual, I am heard, I am respected, I am understood, then I'm going to work harder. It's basic human nature. If I'm shouting in the wilderness and nobody's listening and everybody's being horrible to me and I don't really understand why because nobody talks to me, what am I going to do? So absolutely individual performance is fundamental to the success of mediation and vice versa.
So the one figure that stuck out for me was the $28.4 billion is the cost of conflict. Pounds sterling. So in dollars it would be even higher. That's the cost of conflict in the UK every year. So just repeating that number, 28.4 billion pounds. That's an astronomical figure spent on, well, resolving disputes would be wrong. It would just be dealing with disputes or being involved in disputes. That's the amount spent. Finally, but we have a lot more questions, but let's take this one last question. Do you believe that there are any types of disputes in the workplace for which mediation is not the best approach?
Well, very few, but they are the ones which cannot be resolved by agreement. They are the ones which have to be resolved by instruction. So if I tell a junior in my department that I need him to do this and I need him to do it now and he doesn't agree, then that's not a mediation matter, that's just a do it matter. And fine, if I am very rude to him in the process, or unnecessarily rude in the process of telling him what to do, that's a slightly different thing. But do it now, please, is not mediation. Serious misconduct is not made better for the company because two employees might decide between themselves that it doesn't matter. So that's not really a mediation matter. If somebody comes into the mediation process making it clear that they are not interested in compromising, there's no point in going on with that. But as I said earlier, otherwise, anywhere you've got two people who might have to work together again in future, then you've probably got scope to mediate. The great thing about it is that if it fails, it doesn't matter, because you can still go on to a formal process. But in that failure, the employer may have learnt an important lesson. And the lesson that it has learned is that this isn't going to work as a relationship, so one of you has to leave. Now in England, there'd be all sorts of argument about who is it and why and how sure are you and couldn't you have done more and so on. But if you've invested, as Mihir says, you've invested some money in an external mediator, that is a visible sign of your commitment to making it work. And in the end, if it doesn't work, somebody will have to leave and you have the proof right there in front of you. You've also got this extra little bit of leverage, which is who wants to be the person who is the reason why a dispute could not be resolved. Because actually, even if you're the innocent party, if you refuse to mediate, you've made yourself the problem, not them. That's not a good place to be. So it's worth trying in almost all cases.
Wonderful. Thank you so much, Caroline and David. And now I would request anybody who has any questions from the audience.
This is just to supplement the question which moderator has asked regarding mandatory mediation. What I mean that reference can be mandatory. We understand the process is voluntary, it's a strategic process. So reference can be mandatory, mediation process is voluntary. So in India also, when my experience as a mediator of Bombay High Court and the State Consumer Commission, and High Court used to refer the matter without the consent of the parties, their matter is fit to be mediated. So mediation can be mandatory, process may be voluntary. So that is, I think, I want to clarify. This can be done. Even in, I think, in Mumbai, in India, Commercial Courts Act, Section 28. This also makes mediation mandatory in certain matters may be up to I think 30 lakhs, 3 lakhs if I am not wrong. So mandatory this mediation is already in existence in India. Secondly, why it should be there? Considering more than 25 crores of the cases, 5 crores means amount to 50 million of the cases in India. So reduce penalty. The people are more in Indian countries, people are more inclined to go for the courts than the mediation. That culture we have not developed the culture. So I want to just enlighten on this point in the Indian context.
Well, in England, there is a pre-claim process called early conciliation through ACAS. You cannot start an employment tribunal claim until you have applied to ACAS for early conciliation. At exactly the same time as you apply, you are entitled to say to ACAS, I don't want any discussions with my employer, and it's over. That day, it doesn't work. That day, it's finished. So in that sense, there is a mandatory opening of the door to a discussion, but there is no mandatory participation in it. At all.
It cannot be. Reference only can be mandatory. Process ultimately is voluntary. Yes.
I think these are questions that my colleagues at the Civil Mediation Council and others around dispute resolution body and ACAS are asking, but we're not at that stage yet. We're having discussions around how does mediation need to evolve, in what way, it's only in the forward to the ACAS code at the moment in the UK. The very first question was over the next decade, and so we referenced that our hope is that it will become much more of a tool, the toolbox, than it is currently, and that there'll be more weight put behind the government and some investment from the government, which isn't easy to get. It isn't easy to get.
It will take some time to change the mindset of the people.
Exactly.
And encourage the people to come for the mediation.
Exactly. Thank you.
Excuse me, I would like to tell you that in India, all the rights of the laborers are coming from the Industrial Dispute Act. Now, in the Industrial Dispute Act, there was a provision for a conciliation officer, but subsequently, the government has taken out a law called as a Contract Act, Abolition and Regulation Act, which diluted the rights of all the laborers. Now, I also practice in labor court. Now, since we are having the GATT and policy of liberalization, no rights of the laborers exist. As far as the news readers and anchors and pilots, they are employed on a 3 years contract. So this will not work in India. Because what happens, they are not in a proper, they are appointed on 3 years contract, and the policy of the capitalist is to hire and fire. So according to my experience in 30 years at a bar, I think that it would not be so easy.
Thank you. Any other questions or comments? Any questions or comments on YouTube? Yes?
I have a question.
Hold the mic close to you.
Now that we've known about what mediation is and what the benefits are, I would like to ask what would be the step if mediation fails to resolve a conflict?
Well, if it fails, then everybody learns. So how close to failure, what do we need to do? So that is a beneficial output even from a failure. But if it doesn't work, then you go back to whatever you would have done before. So you go back to established disciplinary procedures or grievance procedures or dispute procedures, all the things that you were both trying to avoid. So mediation is not a replacement for everything else. It is a way of avoiding everything else. But some bad things can't be avoided, and if that means that nobody can get themselves close enough, well, then it's back to where we are now, and everybody will regret it later on, probably, but that's not the point.
Thank you. Just to add to that, it's interesting word failure. Probably still there's a lot learned probably over that mediation. And sometimes it's often the case maybe when it may fail in the day, but it may be a door to keep open in those weeks following actually as well. So keeping close to the parties may also sometimes really help.
Thank you so much. And I think we are done with the questions. And may I request now Advocate Tanu Mehta to give the concluding remarks to our session today. Thank you.
Thank you. Thank all you, Caroline and David. This was a very interesting session for two reasons. One, it also opened our eyes to what cannot work in India, because a lot of things that you all said, we are still in the process of, we're still at an infancy process. So when you, for example, talk about equality, you talk about respect, there are still many steps that need to be taken before we go there. But at the same time, I absolutely adhere to David's optimism that mediation has to work. Because I myself have been a mediator for some years now, and I feel there is no option but to talk things out. Another point that is very important maybe for all of us here is, even if we feel that it will not work, the ability to give voice to the voiceless is by itself a very big step. Because like you mentioned, sir, and like a lot of us know in India, a lot of sections do not have the voice. And it's not only having voice against maybe an employer, even within their unions, if there are unions, or even within associations, they don't have voice. Because in India, we don't only have hierarchy between employers, we also have hierarchy of unions and politicians trying to control unions. So even if I, as a woman, was trying to get something out, my agenda would probably be hijacked by some politician, by some union leader, by some lawyer, and they would go on a different track from something that I just wanted as an employer or worker. So there are many hierarchies in India, and the ability to give people a place where they could find safety, like you mentioned, where they could find a voice, where they could vent out, and where they could have the freedom to think through all their, adversarial, whatever situation, and then rationally come to some solution that would be acceptable to them. That itself is a big step, and I think that only mediation can do. So I feel that despite where I understand where we stand, despite that situation, mediation is one thing that will work more than litigation. Though of course, why litigation won't work in India and why litigation doesn't work in your country, there are different reasons. Like you said, for you, the cost of conflict is very high. For us, maybe it's not, because we live in a different ecosystem. We have a lot of subsidizing of conflict via lawyers, via associations. But, basically the cost may not be very high, but the inability to find resolution is very, very high here. And for that reason alone, going into mediation and finding a closure, finding a resolution can work very well in this country. So, for all the right reasons and the wrong reasons, this is a very, very interesting and enlightening talk. Thank you so much for taking the time, for waiting for us so patiently while we acted the typical Indian way, came late, etc. But nevertheless, thank you, and it was very nice to hear you. Thank you.
And just to conclude, I would like to thank Caroline, David, Mr. Rajiv Patil, Mr. Ashok Hende, Sri Chetan Bhagwat, he is not here, Mr. Santhan Krishnan sir, and all the people present here today, in person and on YouTube. I know there has been a slight problem with the audio, especially on YouTube, and I do apologize for the same. There has been a technical challenge that we could not unfortunately overcome. But thank you all for finding the time to come here and listen to us and grace this occasion. Commonwealth Lawyers Association, Mediation Initiative, my organization, and Nivaaran, the Supreme Court Mediators, all three organizations came together to organize this, and once again, thank you to all and have a good night. Yes, of course, there's some refreshments at the back. Yes?
Sir, participate group photos.